ay ang ebidensya ang ebidensyang makukuha sa iyo ay isi-certify ng isang laboratory, no, na kung saan ay sasabihin kung ano yung weight, ano yung purity ng evidence. While I do understand the apprehension of Congressman Teves doon sa pagpapababa ng purity na maaaring maging basis for maybe acquittal or maybe dismissal of a case against the accused. Ang ating pong dito ay na-certify na ho yan ng laboratory. So kung na-certify yan and there was already a certification issued about the weight, the quantity, and the purity of the substance, whatever happens after that, perhaps kung i-present yung ebidensyang yun again sa korte, we will just probably let the courts decide dyan sa puntong yan. Your Honor, Mr. Speaker.
Oh, lastly, Mr. Chairman, again, can I get a categorical answer? If you are caught with a diluted 200 liters of water containing 5 grams or even just 1 gram of shabu, how much shabu will be charged to you? 200 grams? 200 kilos or 5 grams?
Well, if upon apprehension, the PIDEA Crime Lab certifies that the evidence found in your possession is 200 grams, then it will be 200 grams.
No, because ganito nga 5 gramo lang yon tinapon sa isang drum ng tubig. 200 kilos yung isang drum ng tubig. So, paano ka matcha-charge nun? Halimbawa, naka-plastic yun. Natapon doon yung plastic, butas, tunaw na. When you test that water, it has very, very small trace of shabu. But again, ang totoong volume nun, 200 liters, which is equivalent to 200 kilos in weight. Anong kaso mo nun sa korte ng posesyon? 200 kilo na shabu or 5 gramo ng shabu? Yun lang naman, Mr. Chairman. Para lang maklaro natin at para ngayon pa lang mapag-isipan na rin ng mga korte kung anong take nila doon later.
Yeah, I agree, Mr. Speaker, distinguished colleague, na maaaring bumaba yung weight nung sinasabing ebidensya. But, of course, if yung sinasabing senaryo, Mr. Speaker, ng ating butihing congressman from Negros, ay during the time of the apprehension, habang hinuhuli siya ng pulis, ay itinapon niya sa tubig, whatever is found that could be deciphered as a shabu, yun lang nga po ang may charge sa kanya. Yun lang ang may charge sa kanya. Kasi, remember, the possession itself is already an unlawful act. Therefore, punishable under our laws.
Yeah, Mr. Chairman, Mr. Speaker, ganito kasi yan Ang shabu is very soluble. Pag tinapon mo yan sa tubig, automatic tunaw yan. 1,000% tunaw yan. Lalo na pag masyadong maraming tubig at ang konti ng shabu. Again, if I may repeat, 5 grams, tinapon mo sa isang drum, 200 kilos of shabu solution yun. Yun lang. I don't think we'll get into a resolution now. I just wanted to reiterate it. Again, I hope the senators also, dadaan naman to sa kanila din, sana mapag-isipan din nila at magawa natin ang magandang solusyon. I understand very much the intention of the chairman. Kaming dalawa magkasama nito gumawa Ako yung vice chairman niya dati. So kaya alam na alam ko to. matagal ko na itong pinakiusap sa kanya. At sabi ko nga, Chairman, sana naman hindi na dumating na tayo pang dalawa magtalo dito dahil nakakahiya. Dahil ikaw yung chairman ko, ako yung vice chairman mo, tayo yung gumawa nito. Sabay tayo pa magtatalo sa batas na ito. So again, magtulungan na lang tayo. I hope we get into a positive resolution to this really, really important concern. That's all, Mr. Speaker. Thank you very much.
Thank you, Mr. Speaker. Thank you, distinguished colleague. But let me just state that while I understand the apprehension of the gentleman from Negros, the intention of this proposed amendment is only to determine not the purity, but only the weight or the amount of the illegal substance found either in his possession or maybe discovered while there was an unlawful act being committed as stated in the Republic Act 9165. So, yes, we will consider the idea and the suggestion of the gentleman from Negros. When at the appropriate time, maybe he can help the committee to frame up perhaps a phrase or a paragraph that can be inserted into the amendments at the appropriate time, Mr. Speaker. Thank you very much, distinguished colleague from Negros.
Majority Leader.
Mr. Speaker, next to interpolate is the Honorable Christopher Belmonte.
The Honorable Christopher Belmonte is hereby recognized.
Thank you very much, Mr. Speaker. Good afternoon po. Will the Honorable Sponsor, the dashing ace barbers who comes from line law enforcement officers and expert in the matter,
Mr. Speaker, I'm sorry I wasn't able to hear.
payag ka bang magpa-interpolate? Shortcut.
Gladly, Mr. Speaker.
Thank you. Thank you very much, Mr. Speaker, Your Honor. First of all, let me state na I agree with the sponsor and the committee na kailangan nga po talagang ma-amend ang 9165. From a long-standing practical experience, law enforcement and legal practice on the ground, kailangan po talaga. And kailangan lang po nating linawin kasi pwedeng maganda ang epekto nito, pwede ring makasama po para sa ating lahat. So, just for my clearer understanding, Mr. Speaker, may the sponsor provide us with the objectives of the amendments, of this set of amendments to the law, Mr. Speaker, Your Honor.
Gladly, Mr. Speaker, distinguished colleague, the reason why we introduced legal presumption in the fight against illegal drugs is because we'd like to run after not just the ordinary street peddlers of illegal drugs, but also run after drug lords or big-time drug syndicates, because it seems that there are cases where it was dismissed for simply lack of evidence or simply lack of weight as to the involvement of a certain person other than the street peddler. So kita ho natin na medyo marami tayong dapat gawin. The biggest question, Mr. Speaker, is paano ho natin makakasuhan, makukonvict o makukulong itong mga sinasabi nating drug lords. They are not the ones selling the drugs in the streets, nor you cannot see them negotiating for a sale or a trading of this illegal substance. So napakahirap po.
Thank you, Mr. Speaker, Your Honor. So tama ho pa ang pagkaintindi ko. Ang gusto po natin dito ay palakasin yung capabilities ng law enforcement officers para mahabol po nila yung talagang mga drug lords, yung mga big time na nagtutulak ng droga. Hindi lamang po yung mga street level at saka lalong-lalo na ho para ma-prevent din yung paglaganap ng usage nitong illegal drugs.
That is correct, Mr.
That is,
Speaker, distinguished colleague.
If I understand it. And left unspoken is para hindi ho mag-resort sa shortcuts yung ating mga law enforcers or mag-resort to extrajudicial killings para lang ho manalo sa gera na to. Tama po ba yun, Mr. Speaker, Your Honor?
Tama yun, Mr. Speaker, distinguished colleague. In fact, para lang malinaw, ang objectives o yung key provisions nitong amendment na ito ay, if I may, Mr. Speaker, distinguished colleague, one is it provides for a legal presumption on who is considered as importer, financier, protector, or cuddler of illegal drugs. Number two, to penalize negligent lessors of properties. Kasi there are instances where clandestine laboratories are discovered in condominium units or houses being rented out by syndicates. So dito sa batas na ito, dito sa ating amendments, we will already penalize negligent lessors of properties that were used as clandestine laboratories. Kasi dapat ho, meron silang role. In fact, in this proposal, we will compel them to comply with some documentary or repertorial requirements. No? Kagaya po yung kanilang pag-inspect sa kanilang mga properties or sa kanilang mga units. Third is to mandate the conduct of drug testing of Filipino professionals and non-professional athletes. Maraming cases where, meron tayong atleta na nakikilala na dahan-dahan and then eventually nasisira yung kanilang career because they are discovered to have been using illegal drugs. So ito, with this amendment, kinokompel na natin na bago ka pa mag-represent sa ating bansa bilang isang atleta, ay kailangan meron ka ng certification that you are drug-free at hindi ka gumagamit ng illegal na droga. Next is yung extend the criminal liability to the partner, president, director, manager, trustee, estate administrator, or officer of the corporation or partnership who consents to or tolerates the use of the property of the corporation or partnership as den, dive, or resort. Maraming cases ganito, no? Restaurants or resorts are being used as drug dens. And masyadong maluwag no, sa interpretasyon natin na walang kinalaman yung may-ari. But there are times, there are cases where the owner allowed the use of his property as a drug den because perhaps for monetary consideration. So, ang mga major objectives itong proposal na ito, Mr.
Thank
Speaker.
you for that, Mr. Speaker, Your Honor. If the sponsor will allow me, pasukan po natin maya-maya yung presumptions at saka yung given yung objective na madali big time. For a matter of housekeeping lang po, for my comfort level, the comfort level of this representation, Mr. Speaker, Your Honor. During the committee hearing na pinag-usapan po natin, again, itong amendments na to ng Dangerous Drugs Act, a number of sponsors initially stated their intent to withdraw from sponsorship of this bill dahil sa kinabahan ho sila na the provisions as stated were in effect reviving the death penalty, Mr. Speaker, Your Honor. In fact, I do recall joining the sponsor, the committee chairman in this matter, in pleading to our colleagues and taking the position na ang pinag-uusapan po natin dito ay yung revision ng Dangerous Drugs Act and hindi po yung death penalty. And the chairman of the committee himself stated na hindi natin gustong pasukan ng death penalty dito. In fact, ang gusto po natin gawin ay iwanan po yung the matter na yon sa proper committee, which in this case would be the Committee on Justice. And we confine ourselves dito lang po sa usapan ng dangerous drugs. Is that not correct, Mr. Speaker, Your Honor?
Yes, that is correct. I remember, Mr. Speaker, distinguished colleague, that the gentleman from Quezon City clearly emphasized that particular point and asked this representation whether are we trying to amend or repeal the death penalty law. Now, let me just state, Mr. Speaker, distinguished colleague, that perhaps what caught the attention of the distinguished colleague from Quezon City and all other authors was the provision, the penal provision on Section 13 of RA 9165, which makes reference to Section 11, where the penalty for violation is maximum penalty of life imprisonment to death. So, ang pong nakasulat po doon ay nakalagay lamang po doon ay maximum penalty. We purposely, Mr. Speaker, distinguished colleague, wrote the phrase life imprisonment to death so that in order to avoid yung vagueness of the penal provision. Kasi that is what the law says anyway. Ang nakalagay po doon ay maximum penalty. But if you spell out what maximum penalty would be, this is the life imprisonment to death. We never attempted to repeal the death penalty in this case, Mr. Speaker, distinguished colleague.
Thank you very much for that clarification, Mr. Speaker, Your Honor. In fact, thank you for correcting, anticipating my question and correcting me. I was under the impression that this was Section 11 amending Section 13. Which reads, as amended by our proposed law, any person found possessing any dangerous drug during a party or at a social gathering or meeting or in the proximate company of at least 2 persons shall suffer the penalty of life imprisonment to death and the fine of 500,000 pesos to 10 million pesos, regardless of the quantity and purity of such dangerous drugs, Mr. Speaker, Your Honor. And the purpose of putting this amendment in Section 13 is because the RA 9165, the original law, did not contemplate imposing the maximum penalty of death to a person found in possession of drugs under these circumstances. Is my understanding on the matter correct, Mr. Speaker, Your Honor? Otherwise, 9165 would have put that specific wordings as it did in other similar provisions imposing penalties by imposing the maximum penalty of death. In other provisions under the original 9165, which we intend to amend, specifically they stated that they wanted that the death penalty was an option. Is that not correct, Mr. Speaker, Your Honor?
Yes, Mr. Speaker, you are correct in that interpretation because what the committee did, Mr. Speaker, distinguished colleague, is only to spell out the penalty, the maximum penalty, and the amendment would read, delete the maximum penalty and instead spell out what the maximum penalty is in our present laws.
Correct, Mr. Speaker, Your Honor. In other words, it is contemplating the possibility, if our laws would allow, laws and jurisprudence and the justice system would allow, contemplating the death penalty in the circumstance of a person found in possession of dangerous drugs in a gathering or of at least 2 persons, which wasn't contemplated by the original 9165. Is that not correct, Mr. Speaker, Your Honor?
No, Mr. Speaker, distinguished colleague, that was not the intention. We did not touch on the penalty. If you notice, most of the amendments that are being proposed are only on the legal presumptions.
That is correct, except for this specific provision, Mr. Speaker, Your Honor, which did touch on the penalty. May I add another point, Mr. Speaker, Your Honor? We were both members of the 17th Congress, Mr. Speaker, Your Honor. And I do recall that after it passed on third reading, this particular bill was returned to the committee by the plenary itself, precisely because of this specific provision, which in essence was subject to the interpretation that we are allowing the death penalty or legislating anew the death penalty for this specific circumstance, Mr. Speaker, Your Honor.
Mr. Speaker, distinguished colleague, tama po yung observation ni Congressman Belmonte. However, the original law already states in Section 11, sa possession of dangerous drugs, the penalty of life imprisonment to death. So this was already stated, explicitly stated in the Republic Act 9165. So ang ginawa lamang po natin ay we did the same to all other sections with a provision, with a penal provision of life imprisonment to death. We just spelled it out, Mr. Speaker, distinguished colleague. So wala ho kaming repeal, wala ho tayong inimpose. In fact, during the last Congress, yes, I do remember that it was recalled for a while. But after discussions with the Committee on Rules, and after finding out that there was no intention to repeal the death penalty or even amend the penal provisions, it was approved on third and final reading during the last Congress, Mr. Speaker. So, dito ho, gaya ho ng sinabi ko kanina, ay wala ho tayong initiative or attempt or plano to change whatever was stated as the penalty for any violation of this 9165, Mr. Speaker, distinguished colleagues.
Thank you very much for that, Mr. Speaker, Your Honor. The clarification is much valued. However, it is still a dangerous addition, specifically because as our law stand and jurisprudence stand, the law repealing the death penalty is still in effect, despite the intentions of many of our colleagues in the House to reimpose the death penalty, and I must say, with some justification and reasonableness on their part. However, the law, thus, as it exists now, says that no death penalty shall be imposed as the maximal penalty. Is that not correct, Mr. Speaker, Your Honor?
Yes, as it is, because there was a suspension of the imposition of the death penalty. Therefore, it still holds as what the law says. However, we cannot impose death on any violation as a penalty for anyone who violates any provision of this act, Mr. Speaker, distinguished colleague.
Please correct me if I'm wrong, Mr. Speaker, Your Honor. I'm sure the Speaker will know better on the subject matter than I do, Mr. Speaker, Your Honor. But it is my understanding, Mr. Speaker, Your Honor, that when two laws ang pinagbangga po natin, dalawang batas po ang pinagbangga po natin, the later law will prevail over the earlier law. Which means na dahil pareho, the intent of the legislature during an earlier period will be superseded by the intent of the legislature in a later law as enacted. And suppose presuming that we do pass this law as it is written, Mr. Speaker, Your Honor, and this amendment in Section 11 correcting Section 13 being a later law will then allow the death penalty for the specific circumstance of persons found in possession of dangerous drugs with the said amount in the presence of two or more other persons. Wouldn't that be the proper interpretation of the law and jurisprudence as it stands, Mr. Speaker, Your Honor?
Yes, Mr. Speaker, distinguished colleague, you are correct. The later law will prevail. But again, as I stated earlier, there was no intention to repeal or amend the penal provision of Republic Act 9165. Now, if the good gentleman and the distinguished gentleman from Quezon City would be kind enough to perhaps rephrase whatever at the appropriate time, rephrase what we intend to spell out here in this proposal, then I guess the committee will not have any questions about
Thank
that.
you for that,
Because
Mr. Speaker,
if
Your
this-
Honor. I very much appreciate that, and at the proper time, I hope that the proper amendment may be introduced by this representation or the committee itself so as to clarify any vagueness.
Yeah,
Thank you for that.
This representation appreciates very much the proposal at the appropriate time that will be forwarded by the distinguished gentleman from Quezon City in order to avoid vagueness again of the interpretation, because there was really no intention to change or amend the penal provision. We are just proposing legal presumptions in order to help, support, and aid our prosecutors in getting a conviction to those that are really in the business of illegal drugs. Not just the ordinary street peddlers, Mr. Speaker.
And I thank the honorable sponsor, the chairman of the committee, on that, for that. He did state that specifically at the outset of the series of committee hearings to tackle this committee. I would just like to make sure na malinaw na hindi ho natin masisingit yung death penalty through this, kung hindi rin naman ito yung intention po natin. On a side note, Mr. Speaker, Your Honor, I remember a case noong May 2016 na Close Up Forever Summer Concert. Yung may limang biktima na namatay dahil sa overdose. At isa lang ang nahuli, yung suspected seller nung araw na yon. Pero due to follow-up operations sa galing ng law enforcement officers po natin, a week later or so, through the follow-up operations po nila, naka-aresto po ng 5 pa na additional suspected drug dealers. And I presume later on down the road, natuntun din nila yung drug lord behind the scene. My point here, Mr. Speaker, is ang objective ng batas nga natin ay para madali yung drug lord. Hindi po yung ordinaryong tulak at maproteksyonan yung mga biktima nila. Hindi ho kaya pag ganito ka-vague yung batas natin at nandyan yung mga similar penalties na katulad mas madaling tumahimik na lang o hindi na lang gumalaw or hindi na mag-follow up yung mga police para magtuloy ng operation doon. Kasi may huli na sila eh. Maximum penalty na naman to eh. Diba? Anong incentive nito para kumanta? Anong incentive nito para maximum na siya eh. Anong areglo mo? Under our laws, the law enforcers, under our criminal code and criminal procedure, least guilty ang pwedeng maging state witness. Under these provisions, maximum na silang lahat. Wala nang, parang natanggalan natin ng bala ang ating law enforcers. Parang incentive na yung simpleng tulak o yung biktima ay kumanta. Kasi si biktima, si simpleng tulak, death penalty na rin sila anyway. Hindi na rin nakaka-avail ng mga areglo na pwedeng ibigay ng law enforcement officers para madali yung mga big shot. Hindi ho kaya may ganong epekto to, Mr. Speaker, Your Honor? Tatanong ko lang po.
Yes, very tragic, Mr. Speaker, distinguished colleague, yung nangyari doon sa na-overdose. No? In fact, she was clearly a victim, no, of the legal drugs. No? At dapat managot, hindi lamang yung street peddlers. And with the follow-up operation made by the enforcers, they were able to apprehend yung iba ring involved. Kasi hindi lang pala isa, dalawa yan. It appears to be a syndicate, no? Where the syndicate, apparently, no, ay meron ding information ibinigay kung saan yung source nung drugs na yon, no? I read some of the details of the case, and I remember na meron until now, no, they're still doing a follow-up operations because the same type of drug, yung party or cocktail drug that they call it, yung ecstasy, the same quality, the same look. Kasi ngayon ko lang nalaman, Mr. Speaker, na iba-iba pala itsura niyan. But the same look, which was apparently taken by the victim, was still proliferating in the same area. And this apparently came from the same syndicate. So hanggang ngayon, pina-follow up pa rin ho yan ng mga law enforcers sa PIDEA. So, kaya nga ho, gusto natin na kung sakaling mahuli itong mga ito, of course, they will definitely deny, no? As the normal, natural reaction nila, they will deny any involvement. Sabihin nila, hindi naman ako yung nag-abot, hindi naman ako yung nagbenta eh. But kung tinuro siya as the source, then we can use now the legal presumption and let him defend himself in court. Yun lang po ang ating objective dito, Mr.
I understand that, Mr. Speaker, Your Honor, and I beg the indulgence of the honorable sponsor. Pag-usapan natin yung presumptions bandang dulo, and if the sponsor will allow me, kasi importanting topic to, lalo nang nag-a-allow tayo ng presumptions on presumptions to that on the later part of my interpolation. Pwede we both have more time to prepare on that subject matter. However, Mr. Speaker, my point is, as to the penalties and the bargaining, I'm thinking about it from my limited experience with our law enforcement. Ang pinakamadaling paraan para makuha nila kung sino yung bossing ay para kumanta yung nahuli nilang small fry. At para magawa nila yon, allowed sila ng batas, ng tools, para pwede nilang i-negotiate yung small fry. Point ko lang po dito, Mr. Speaker, Your Honor, by imposing the maximum penalty dito, hindi ko siya sabing mali. Tanong ko lang po to. Hindi po ba tinatanggal natin yung option, yung availability para sa law enforcement officers natin na magamit yung small fry para makuha yung big fish, Mr. Speaker, Your Honor. Hindi po sa presumptions. Nandun pa lang po tayo sa paano niya papakantahin yan. Sort of reducing, using shortcuts, Mr. Speaker, Your Honor. The tools, the legal tools provided by our laws and the rules of criminal procedure for our law enforcement officers is the law itself. Would not this imposition of the maximum penalty, likewise for small fry, limit? I'm just saying, Mr. Speaker, I'm not saying it is right or wrong. I'm just asking the question, Mr. Speaker, Your Honor, for my better knowledge and clarification.
Well, Mr. Speaker, distinguished colleague, meron po tayong provision dito sa ating proposed amendment on Section 33A, the immunity from prosecution. And this can be used as a bargaining chip or a tool, no, for the apprehended suspects to be able to bargain and, provided that he gives out valuable information. So, nandito ho yan. Nakasama po yan sa ating proposal. Section 33.
Thank you for that, Mr. Speaker, Your Honor. Ang pinapoint out ko lang po, magbabangga, I don't disagree with that provision. In fact, I fully agree na that option should be available to our law enforcement officers. Ang sinasabi ko lang po, pagdating nito sa prosecution, sa korte, ang dahil sa banggaan nito and our existing criminal procedure, hindi na siya least guilty. Kasi maximum penalty din siya. Yun lang. Yun lang ang point ko. Baka lang kailangan lang natin silipin yun, Mr. Speaker.
You have a point, Mr. Speaker, distinguished colleague, doon sa punto na maaaring hindi na mag-avail siguro, no? At the committee just made sure that the immunity from prosecution is available to any of these suspects who wish to spill out any information relative to the source or maybe to the drug lord na rin, na kung saan siyang nagbibigay o nagsusupply sa kanila. Siguro, Mr. Speaker, distinguished colleague, again, to make it a little bit clearer at the appropriate time, I would entertain the proposed amendments by the distinguished gentleman from Quezon City.
Thank you for that, Mr. Speaker, Your Honor. Hindi pa to a proper time, pero it just came to my mind. Nakita ko yung front page ng Inquirer today. Hindi ko nabasa yung eksaktong wordings, pero ang pagkaintindi ko, ang sinasabi ngayon sa trial ni Senator Laila de Lima, ang sinasabi ng testigo ay wala naman silang nakitang direct connection between, at least the testigo ngayon, walang direct connection between Senator Laila de Lima at saka yung proliferation at yung pagbenta ng drugs coming from the National Bilibid Prison. However, dahil doon sa mga nangyari, there was sufficient grounds under our present laws as existing ngayon, keep an sitting senator of the land in detention, Mr. Speaker, Your Honor. It is not exactly related now, pero naisip ko lang po na these are the dangers of the law as it stands now. Di kaya pag pinatigas pa natin, hindi kaya baka lalo pa nating mag-create yung ganong situation. Remember, Mr. Speaker, Your Honor, I do not recall who said this, but the whole point of our criminal justice system is to protect the innocent. It's just a side note, Mr. Speaker, Your Honor, and maybe I don't require a comment from the honorable sponsor on this matter. If I may just move on.
But let me just comment just the same, Mr. Speaker, distinguished colleague, that yes, I perfectly agree that the justice system must serve the oppressed. I'm not very privy about the case that Senator De Lima is facing right now as to what evidence, what charges were filed against her. But if only to improve our laws with respect to that kind of a scenario, again, this representation would be more than willing to entertain any proposal from the distinguished gentleman from Quezon City as far as that subject matter is concerned.
Thank you for that, Mr. Speaker, Your Honor. may aside dito si Congressman Caloy, pero hindi ko na po babanggitin ngayon, Mr. Speaker, Your Honor. Mukhang may balak ang makabayan na mag-introduce ng substitute bill, Mr. Speaker, Your Honor.
We will consider whatever proposal is available.
May I move on to my second topic, Mr. Speaker, Your Honor? If the sponsor and the chair will allow me, Mr. Speaker, Your Honor. Let's talk about physical manifestations. Physical manifestations. On Section 12, amending Section 15, the bill expounds on the penalties for dangerous drugs use. A person is apprehended either through treatment or through imprisonment, but only when he or she is found to be positive after a confirmatory test. Is that correct? Section 12, amending Section 15. Ang sinasabi po nito, kukunin ka, the intention of this is to, yung user. Ang point is, bago ka hulihin, for treatment or para ikulong ka, kailangan may confirmatory test. More or less, yun yung ibig sabihin nun. Tapos, ang sinasabi niya, yung mga napatunayan ng test na drug dependent, 6 months na treatment. At pag hindi ka drug dependent, 6 years imprisonment. Pag hindi ka drug dependent. Tama po ba yun? Is that correct sa understanding ko of Section 12 amending Section 15, Mr. Speaker, Your Honor?
Yes, Mr. Speaker, you are correct. You are correct, Mr. Speaker.
Thank you very much, Mr. Speaker, Your Honor. So, doon po muna ako doon sa part ng provision na to na pinag-uusapan po natin yung physical manifestations. Ang sinasabi kasi, para ka ma-confirmatory test, para ma-test kung may drugs ka sa katawan mo, dalawang grounds ang pwede. Dalawa lang ang kailangan. May physical manifestation of drug use, ang tingin ng enforcement officer, gumagamit to. At saka pangalawa, ayaw mo magpa-test. Sabi niya, magpa-test ka, ayaw mo. Pwede ka na niyang kunin. Pwede ka na niyang i-apprehend para mag-require at i-require na i-test ka. Tama po ba yan? May third part dun na sinasabi, pero hindi ito requirement. Parang assume na. May possession ka ng paraphernalia. Nakita ka ng foil, nakitaan ka ng foil, nakitaan ka ng tutor o instrument o lighter, may presumption na dun. So it's, may gamit ka na pang shabu. Hindi pa yung possession, ha? Hindi pa yung actual drugs to. May gamit ka. Pero kahit wala yun, mukhang guilty ka. Mukha kang gumagamit. At ayaw mo magpa-test. Pwede ka nang kunin for test. Tama po ba yun? Tama ba yung pagkaintindi ko dito, Mr. Speaker, Your Honor?
Yes, Mr. Speaker. In fact, dito sa section na ito, ay tama po kayo, no? Dalawa po yung points, no, na pwedeng makonsider that you are a user. Dito muna tayo sa user, no? One, kapag during apprehension, meron pong manifestation na ikaw ay gumagamit nung ikay nahuli. Maaring merong something sa iyong physical appearance, maaring sa mata mo, o maaring siguro sa mga galaw at kilos mo, no? Number two ay you refuse to submit yourself to a drug and confirmatory test. Ito po yung disputable presumption na pinopropose po natin. Dahil ang idea po natin dito is that if you refuse to have a test
Mukhang guilty.
as well as a confirmatory test, may tinatago po kayo.
Mukhang guilty ka.
Mukhang guilty ka.
Mukhang guilty
Dahil
ka.
may tinatago ka, you are presumed to be a user. And,
Mukhang guilty
in the
ka.
course of your defense, siguro sa korte, ang husgado na po ang bahala magsabi kung ikaw ay gumagamit o hindi.
Thank you for that, Mr. Speaker, Your Honor. Side note lang po. Inaasar po ako ng staff ko kagabi. Kasi napanood nila sa Facebook Live. Facebook Live pala tayo dito. Facebook Live po pala tayo dito. And during my previous interpolation nung kay Congresswoman Sara Ilago sa UP-DND Accord, daming trolls at bashers daw. At ang sabi ng mga trolls, yung congressman na yan, kasi lawlaw ang suot ko, mahaba buhok ko, may eye bags ako, gumaganyan ako, at saka likot ko dito sa podium, mukhang addict yan. Yun yung sinasabi nila. Yun yung sinasabi nila. Buti na lang pag tinanong ako, papadrug test ako, sabay tayo, wala akong problema. So makakalusot po ako dito. Pero my point is, ang daling sabihin ng physical manifestation. I recall also a certain situation, Mr. Speaker, Your Honor, na ang pinaglalaban namin ay lupa, land issue. And of course, sanay na sanay yung mga pulis na magbabarikada yung community para malinis ang enforced na demolition nila. Bago nun, pumasok sila sa community at saka yung mga lahat ng mukhang user, mukhang tulak, may tattoo, may signs na EP, pwede nilang kunin muna for questioning. Wala pa tong batas na to, Wala pa tong batas na to. Pero dinala muna nila sa station for questioning. Malinaw sa lahat, issue ng lupa. Pero in essence, lahat ng kalalakihan sa buong community na yon ay wala nung dumating ang demolition team. Kunikwento ko lang po, Mr. Speaker, Your Honor, and this was before this law. Pero let's go to the UND, lagyan po natin ng medyo mas linaw yung physical manifestations, Mr. Speaker, Your Honor. The UN Office of Drugs and Crimes identifies some physical effects of certain drugs. For example, LSD equates LSD, shabu, dilated pupils, nausea, vomiting, profuse sweating, rapid heart rate. Other effects may also include emotional instability and perceptual disturbances. Sa ecstasy naman, sabi din ng UN, high blood pressure and heart rate, nausea, restlessness, visual or auditory hallucinations. Minsan parang nakakita rin ako ng Supreme Court Justice na parang may kausap na Sorry. Would you agree that these physical manifestations are defined by the UNODC are enough to give rise to reasonable suspicions? Sabi na ng international studies, ito yung mga manifestation. Pwede na ba yan?
Well, Mr. Speaker, distinguished colleague, yung po mga nabanggit po na mga manifestations ay hindi po gawain ng isang normal, sober, at isang taong walang impluensya ng kahit anumang chemical sa katawan. No? So definitely, kapag lumabas po itong mga manifestations na ito, there is something that he probably took in or drank or probably injected or whatever. So sa tingin natin ay hindi normal, dalawang bagay ho lang ho yun. Either gumamit ito ng illegal na droga o talaga may diferensya ito.
So we both agree na the law enforcement officer can use any of these signs according to the law and by the sponsor's own words. A law enforcement officer can use any of these signs.
That is correct, Mr.
That is
Speaker,
correct.
distinguished colleague.
To
However,
implement Section 15.
meron pong kolatilya. Kailangan apprehended siya. Hinuli ho siya. Kailangan may apprehension eh. Kasi,
Di po, ang apprehension ay nasa situation na clarify nyo for me, Mr. Speaker, Your Honor. Ibig sabihin, halimbawa ngayon, dahil sa interpolation natin, pawis-pawis ako. Tsaka kanina pa ako sinisita ng rules kasi lakad ako ng lakad dito. Hindi ako pwedeng arestuhin o hindi ako pwedeng suspicious ka eh. Hindi po ganun yun. Tama po ba?
tama po. Hindi po kayo basta-basta pwedeng arestuhin ng kahit sinong law enforcer. If you are apprehended for a cause, for instance, ikaw ay nakitang nagtutulak, o ikaw kaya ay nakitang humihit-hit ng illegal na marijuana. So that's the time that they will subject you to a test and a confirmatory test.
Or nasa paligid ka ng may gumagamit.
Or nasa palibot ka.
Nasa area ka ng may gumagamit.
Within the premises.
Within the premises.
That's correct.
Yung sa mga presumption and circumstances. Nasa area ka na merong nakitaan ng drugs doon, pwede ka na.
Basta within a
Premises. The
Premises, yes.
I understand the clarification, Mr. Speaker, Your Honor. So malinaw na malinaw, the sponsor is saying na hindi ito anytime.
Yes.
Hindi ito anytime. Para clear lang po.
That is correct.
Thank you for pointing that out, Mr. Speaker, Your Honor. Medyo siguro nabobo ako doon sa pagbasa na ang interpretation ko, anytime basta may physical manifestation at matigas ang ulo ko, ayaw ko magpa-test, yari na ako. Hindi po ganon.
Hindi po ganon.
Ang nito, Mr. Speaker, Your Honor.
You're correct, Mr. Speaker. Doon naman po sa possession of instrument or apparatus, yung disputable presumption pa rin ho doon ay yung the same presumption that was used in the rules of court that states possession of a stolen good, yung fencing. Diba? Kapag nasa iho nahuli yung nakaw na sasakyan, kunyari, you can be charged for...
Parang fencing nyo.
This is the same presumption that we are using. Doon naman ho sa apparatus.
Understood, Mr. Speaker, Your Honor. Hindi po ako masyadong... kasi simple lang naman ang ibig sabihin ng mala prohibitum nga eh. Mukhang guilty talaga. Sorry. Obvious ba? Rather, hindi mukhang guilty. Iba pala yun. Obvious ba? Obvious ba? Bakit kami tutor dyan? May presumption. At kailangan mong ilaban. Yun yung point ng mga mala prohibitum nga naman. Tama kayo, Mr. Speaker, Your Honor. Obvious ba? Yun naman yung point nun. Pero, ang nag-worry lang po ako dito sa physical manifestations, Mr. Speaker, Your Honor. Kasi like I said, ngayon lang na the distinguished sponsor ang ini-interpolate ko, pinagpapawisan ako ng malamig ngayon. At saka edgy ako sa dami ng kapeng ininom ko. So, what I'm saying is, these physical manifestations, even as defined by the UN, can apply actually to other circumstances. And doctors themselves and doctors engaged in the practice of the dangerous drugs prevention and cure themselves have seen addicts who don't exhibit any of these signs actually, Mr. Speaker, Your Honor.
Yes, you are correct, Mr. Speaker. In fact, I personally experienced the same. No, I have friends who are users, but does not manifest any of these manifestations as defined and stated under the United Nations ODC. So, hindi conclusive, no, na kapag mayroong ganitong manifestation, although it gives a sign, Mr. Speaker, distinguished colleague, na you have probably used illegal drugs or consumed illegal drugs if these manifestations are present. But again, the colatilla is dapat meron pong apprehension. Nahuli ho po. Nahuli.
Area. Thank you for that, Mr. Speaker, Your Honor. Kasi nakakatakot nga kung hindi malinaw na sa period ng apprehension. Kasi kung hindi, lahat pwede nang hulihin. Tapos, ang law enforcement officers natin ay pampadagdag ng score, madaming huhulihing small time. Imbis na nakatutok sa big time, users lang dito, ayos na sila. Kompleto na sila sa quota nila, Mr. Speaker, Your Honor. I note, Mr. Speaker, Your Honor, that my time for interpellation is almost up. And, sensya na po. Di pa tayo pupunta doon sa mga magandang topic, yung esensya ng... and if the rules that the majority will allow this representation and the honorable sponsor and the speaker, if I may be allowed to just continue my interpellation on a later date so that I could give way to other equally important interpellations or matters to be taken up by the plenary, Mr. Speaker, Your Honor.
Yes, Mr. Speaker, distinguished colleague, anytime you wish to ask questions with respect to this proposed bill, this representation would be more than willing to entertain them. Again, let me just state that if there are proposals that the good gentleman from Quezon City has in his mind, perhaps he can help the committee in drafting a amendment when the appropriate time comes, Mr. Speaker.
Mr. Speaker, since the sponsor is amenable to a second round to be given to the Honorable Belmonte, we have no objection on the part of the majority. Mr. Speaker, next to interpellate is the Honorable Sergio Dagook of APEC Party List.
Honorable Celso Dagog is hereby recognized.
Thank you, Mr. Speaker. Would the distinguished seasoned representative of my kababayan, the 2nd District of Surigao del Norte, yield to only 2 clarificatory questions.
Gladly, Mr. Speaker, coming from my fellow kababayan, this representation would be more than willing to reply to his questions.
Mr. Speaker, distinguished sponsor, during the interpellation of my deputy minority leader, I was reminded during one of the committee hearing on the statistics and reports of the PNP in as far as the rate of conviction is concerned. So when I listened to the details of the provisions being amended under the existing RA 9165, I did not hear that it includes some measures to resolve the issue on the rate conviction and the matter about collusion of law enforcement agents, law enforcers, in as far as the enforcement of the law is concerned. So, the first question, Mr. Speaker, distinguished sponsor, kasama po ba sa amendment that will provide penalty or to law enforcers if they are found out to have colluded to the accused, no? If there are collusions that will be found out between the accused and the law enforcers, may penalty po ba yung law enforcer, Mr. Speaker, distinguished sponsor?
Thank you, distinguished gentleman, my fellow kababayan, who is one of the best representative from that northeastern part of Mindanao, the island of Siargao. Yes, you are correct, Mr. Speaker, distinguished colleague, na kasama po sa proposal natin in this amendment, the inclusion of police or law enforcers, including also yung mga prosecutors, including the judges, if they are found to be bungling yung cases. For those naman officers who try to protect or cuddle any suspect for that matter, aiding in the escape or preventing the arrest, yan po ay he will be charged for being a cuddler and protector. And under this proposal, they will be penalized. Life imprisonment to death, the maximum penalty pa rin. So, lahat po ng butas na maaaring matakpan doon sa fight against drugs, no, in terms of apprehension up to the time that we convict the suspect, including the drug lords, including the cuddlers and protectors, ay sinama po natin dito. Because you are correct also that as far as the convictions are concerned ng mga drug suspects, marami ho ang na-reverse ng Court of Appeals. Marami din naman po na na-dismiss sa ating mga lower courts. Pero naman siguro silang legal na basihan because apparently the reasons why cases were dismissed are insufficiency of evidence, inconsistencies in testimonies, non-coordination with PIDEA because the law is very clear, no? Kapag merong drug operation, the lead agency will be PIDEA. And if the PNP attempts to raid a house without the coordination with the PIDEA, then that could be a good ground for a dismissal. So, ito po yung gusto nating i-address, Mr. Speaker, distinguished colleague.
So I am glad to hear that, Mr. Speaker, distinguished sponsor, because I really wrote a note on my reference during that committee hearing, the concern about law enforcers and the rate of conviction. The last point that I am going to raise, Mr. Speaker, distinguished sponsor, is already partly answered by the distinguished sponsor. I would just like to clarify what really, how it is phrased or how it is worded in as far as the roles of engagement problem is concerned. Yung sinabi mo partly kanina na supposed to be PDEA, because it appears in the hearing na nagkakaroon ng negative result yung operation because of some informations being leaked out. Kasi napakahaba pa nung dadaanan ng mga information. So, that is the concern, one of the concern that I have noticed during that hearing. If indeed that was again addressed in the amendment, Mr. Speaker, distinguished sponsor.
Yes, Mr. Speaker, distinguished colleague, kinonsider po natin yan dito sa ating proposed amendments. Although the operational, what do you call that? Operational sequence or whatever
rules
it
of
is,
engagement, ano ba yan?
ito ho ang PIDEA na po ang I share the concern, Mr. Speaker, of my good friend and gentleman from Siargao, that meron talagang malaking problema doon sa coordination. In fact, some of the tips or leaks of operations come from law enforcement mismo. Kaya nga ho, sinasama natin dito, yung kanilang penalty ay mabigat din. Can I ask for a 30-second suspension, Mr. Speaker? No, yung Mr. Speaker, distinguished colleague, sorry it took me a while. Nasa Section 92 po ng ating Republic Act 9165, yung delay and bungling sa prosecution ng mga drug cases. This involves yung ating mga piskal, yung ating mga huwes o yung mga judges. Sa law enforcers naman, ay nandito tayo sa Section 29, which means we covered practically all the bases that we can imagine in order to plug the loopholes at nang sa ganon ay hindi na po mangyari ito. Doon sa operational details na lang, perhaps what we can do is ask PIDEA and PNP to really plug the possible loopholes in their operations so as not to miss out on the suspects that they want to apprehend. So, meron din po, on Section 29, meron din criminal liability yung mga law enforcers. Kadalasan po ng kaso ay ang depensa ho lagi ng akusado ay planting of evidence. So, in the law, it is stated that if found to be guilty of planting evidence, you will still suffer the penalty of maximum penalty. If this is death, then death is what will be imposed on the enforcers na nagplanting. Sa ating proposal, the same section, dinagdagan po natin ng paragraph. Sinabi po natin doon, a defense of planting evidence interposed and pleaded by any person charged for violation of any of the unlawful acts prescribed in this act presumed to be a complaint against the law enforcers or private individuals involved in the arrest, search, and seizure. So very clear na as far as we can imagine, matakpan ho natin yung mga loopholes na yan. Nang sa ganun ay maging matibay yung ating batas laban sa illegal drugs.
So again, Mr. Speaker, ang dinagdag natin yung presumption.
That is correct. This is to support and ensure that complaints, charges will be filed against the top-level members of a drug syndicate. Kasi nga po, kadalasan ang ating nahuhuli ay yung pong mga nagbebenta lang ho sa street o yung tinatawag nating street peddlers na pusher. So, but this time, we will run after, if we pass this law, then it will help the prosecution, it will help our Department of Justice, it will help PIDEA and PNP to run after. Even yung pong mga narco generals na sinasabi, they can already be charged for cuddling or protecting because meron na po tayong ilagay na legal presumption dito sa batas na ito.
Thank you, Mr. Speaker. This representation is really satisfied with the clarifications of the distinguished sponsor. So, I hope that will become into law, the proposed measure. Thank you, distinguished sponsor. Thank you, Mr. Speaker.
Thank you very much.
Mr. Speaker, I move that we suspend consideration of House Bill number 7814.
Is there any objection? The chair is none. The motion is approved. Majority Leader.
I move to suspend session, Mr. Speaker.
Session suspended.